Hello everyone, I am Ankit and you're watching StudyIQ IS. And in today's video, we are going to discuss an important case, that is State of Bombay versus Narasu Appa Mali judgment. And in this case, for the first time in independent India, the courts decided whether or not religion will it be subjected to a regulation of the law passed by legislature. But to understand this case, we have to go back in time, that is in time of India of 1940s. And back then, in present state of Maharashtra, there was this person known as Narasu Appa Mali, and he had taken the permission of his first wife to remarry again. And this in 1940s was not an unusual thing, because especially if a man did not get a male child out of the first marriage, then it was quite common for a Hindu person to remarry again. Now, on one hand, Narasu Appa Mali had the permission of his wife and also social recognition to remarry again. But was it legally allowed as per the law of land? The answer is obviously no. Because few years before Mali remarried while having the first wife, the provisional government of State of Bombay, it introduced a law known as Bombay Prevention of Hindu Bigamous Marriages Act of 1946, which specifically criminalized the bigamy among Hindu persons. That is, you can't remarry again while you have the first wife. And this carried some serious consequences. For example, a jail term will be awarded for as much as 7 years, and also a monetary fine can be imposed in case you decide to remarry again while having the first wife. So this was the context of the case. Now, while understanding the background of the case, you have to understand how this case navigated the courts of the law. Because in 1950s, Mali along with 6 others were sentenced to imprisonment. That is, the sentence to rigorous imprisonment for 2 months along with a monetary fine of rupees 75 based on the judgment given by the magistrate Mr. R.P. Salve. Now, Narasu Appa Mali challenged this judgment in the Sessions Court of Sangli, and in the Sessions Court of Sangli, while they heard the appeal of Mali, and they decided to acquit him of this particular crime. Now, the government of the provisional government of Bombay, they decided to challenge this particular case in the Bombay High Court, and they decided to defend the law's constitutional validity. Now, you have to understand that this law was not passed by a colonial government deciding to interfere in the customs of the land. Rather, it was a decision passed by the government of the independent India, particularly to introduce a measure of social reform among Hindus. So that is why this case becomes important, not just from polity but also from history syllabus. Now, the arguments given by Narasu Appa Mali in this particular case were many. The first argument given by Narasu Appa Mali was that the institution of polygamy, which allowed a Hindu man to carry or to hold more than one wife, it was actually a necessity for a Hindu man in order to perpetuate and further his family by the virtue of sons being born by the wife. And this, according to Narasu Mali, was a part of fundamental right ensured to him under Article 25 of the Constitution, which provided for freedom of religion. And on the other hand, Narasu Appa Mali also said that the Bombay Prevention of Hindu Bigamous Marriages Act, which actually prohibited Hindu men from remarrying again, it discriminated against Narasu Appa Mali solely on the ground of his religion. Whereas on the one hand, this law, it actually discriminated and prevented Hindu men from marrying again, while it did not say anything about Muslim men who were allowed to hold as more as 4 wives at a particular time. So, according to Narasu Appa Mali, this particular piece of legislation, it invalidated or it went against Article 15 of the Indian Constitution, which prohibited state to discriminate against an individual solely on based of his or her own religion. Now, what are the important constitutional provisions relevant from this particular case's perspective? And in this regard, there are 3 important constitutional provisions. First is Article 13. And if you look at Article 13, it states that any law which is inconsistent or in derogation with the fundamental right given in Part 3 of the Constitution, they shall be declared void by the courts of law. Also, this Article 15, it states in absolute terms that state shall not discriminate against any citizens of India solely on the ground of religion, race, caste, sex and place of birth. Whereas Article 25, it provides for freedom of religion, and it explicitly provides for freedom of conscience and the right to freely profess, practice and propagate the religion so as to subject of considerations of public order, morality, health as well as other provisions of the Constitution. So in other words, you can say that Article 25, which provides for freedom of religion, is not an absolute right. Rather, it is a right which is limited by few provisions, that is of public order, morality, health as well as other provisions of Constitution. So these are the relevant constitutional provisions from the perspective of our today's discussion. Now, what were the questions that were raised in front of court of law when it was deciding on this case? The first question, it was whether or not bigamy, is it an essential practice as per the Hindu religion, and if it is an essential practice under Hindu religion, will it form the part of Article 25 that allows a person to practice his or her own religion? Also, can social reforms be applied selectively? Can it be applied just to Hindu community, and the social reform measure, can it not apply on other religious communities? And in that case, whether or not such selective application will or will it not violate Article 15 of the Indian Constitution? Because we learned Article 15, it stated that the state should not discriminate against an individual solely on the basis of his or her own religion. And the third case, whether or not religious customs and practices, can it be considered a law under Article 13 of the Constitution? And if it is considered as a law under Article 13 or of the Indian Constitution, will it not be considered against the fundamental rights of the Indian Constitution? So these were the three questions that were presented in front of the court when it was deciding on this Narasu Appa Mali case. Now, what did the High Court of Bombay decide in this particular case? Now, while considering this case in 1951, the Bombay High Court gave its judgment that the law which was passed by the provincial government of Bombay to prohibit bigamy among Hindu men, it was indeed constitutional. And the ruling given by Bombay High Court, it said that when a son or a male child is not born out of first marriage, the man is not allowed to remarry again solely because he has to get a son out of that marriage. Rather, there is another option in front of Hindu men that they can actually adopt a male child, because male child, whether or not he is adopted or a biological child, they will have a same right under the Hindu law. And as biological sons, they have same rights as adopted sons. Hence, the option of remarrying again just to get a son from that marriage is not open to Hindu men. Whereas, considering the second argument, whether or not social reform measures can they be applied selectively in cases of particular religion, the High Court of Bombay said that the social reform measure that was implemented by provincial government of Bombay, particularly with respect to Hindu community, was based on the fact that there was indeed a demand from Hindu community to seek certain social reforms. And the court, it traced these demands back to the time that even Raja Ram Mohan Roy decided to seek certain social reforms from the government, and indeed it was justified because it was emerging, or the demand for these social reforms, they emerged themselves from the Hindu community, and hence such reforms were implemented only on the basis of consensus. As consensus for such social reforms, it was present in Hindu community where it was not present in other communities. Hence, it was applied selectively in cases of Hindu communities, and hence such selective measures of social reform, they were indeed permissible and constitutional as per the State of or the High Court of Bombay. Understood? Now, what did the court say about whether or not religious customs and practice can they be considered under law as per the Article 13 of the Constitution? Because if you read Article 13 of the Indian Constitution, any law which actually goes against the fundamental right, they can be struck down by the court of law. And in this regard, the Bombay High Court said that personal laws or customs, they are immune from constitutional scrutiny, and they are essentially meant that any personal law, even if they are regressive in nature, they can't be considered by court of law because they are not part of a law which can be considered as a law under Article 13. So in this regard, the Bombay High Court, it actually prohibited the courts from considering personal laws or whether or not these personal laws violated fundamental right, because they are not a part of law according to Article 13. And this 1951 judgment of the Bombay High Court, you'll be surprised to know that this was never challenged in the Supreme Court of India. But does that mean that this judgment will come into a way of implementing other social reforms in future? Then your answer is obviously no. Because if you look at future judgments given by Supreme Court of India, it actually never overruled the Narasu ruling, but it has significantly diluted the notions that are given in the Narasu judgment. For example, in 2017, the Supreme Court of India, it was actually considering whether or not the practice of triple talaq is constitutionally valid or not. And in this judgment, which was given by Supreme Court Justice Rohington Nariman, he actually sidestepped the Narasu ruling, saying that the triple talaq practice, it was codified in the Shariat law, which was actually a legislation, and it does not actually no longer remains a custom. So in that regard, the Supreme Court invalidated this particular piece of triple talaq judgment, and it said that this triple talaq practice is indeed unconstitutional in nature just because it was a part of legislation codified in Shariat law. Had it been solely a custom, then it would not have been able to overrule this particular judgment because it did not actually overrule Narasu ruling. On the other hand, later in 2018, Supreme Court also considered other regressive practice such as banning women in menstrual age from entering the Sabrimala temple, which was based on a religious custom. And this was actually challenged in the Supreme Court of India. Now, Supreme Court actually invalidated this discriminatory practice and allowed women of all ages to enter the sanctum sanctorum of the Sabrimala temple. And in this judgment, the judgment given by then Justice D.Y. Chandrachud is very important, because in his ruling he has said that the Narasu ruling given by the Bombay High Court, it was actually based on flawed premises. And why was it based on flawed premises? Because the decision that was given by Bombay High Court, which actually hold that personal laws, they were immune from constitutional scrutiny. Hence, it was based on flawed premises, because on one hand, customs or usage, they cannot be excluded from the laws in force. And if you decide to carve out these customs or laws from consideration by the court, then you are rather allowing these customs to prevail over the supreme law of the land, that is Constitution of India. Because on one hand, Constitution of India, it provides for certain rights of dignity, liberty and equality, and if you decide or if you carve out certain regressive social practices, then these social practices will prevail over the supreme law of the land. Rather, it should be the supreme law of the land, that is Constitution, that should be supreme in India, and it should allow the values of dignity, liberty and equality to prevail without any social custom or practice to come in between. So what we learned from our today's discussion, that although this Bombay High Court, it allowed the law of the Bombay Provisional Government to pass, and it actually said that the law passed by Provisional Government of the Bombay, it was actually constitutional, but it did not allow the courts to consider the customs or whether or not they went against the fundamental rights or not. But later on, we saw that the Supreme Court of India, it did not allow this ruling given by the Bombay High Court to come in between of implementing the social reforms. Rather, it considered and held that the Constitution of India is supreme, and if any practice, be it custom, legislature or anything, if it comes in between of the values of Indian Constitution, then that will be invalidated by the court of law. So this was all for today's discussion in this particular video. Please stay tuned to our video and subscribe to our channel for more such informative videos in future.